Hi. Oh, no, you're not. You're not. Ausbrook, your mute's on.
Not anymore.
Ta-da! It's
Oh.
Afternoons with Ausbrook.
You're making it sound like a regular thing. Let's not.
No. I believe me. That's why I put the. If you will notice that the S is in parens. Did you? I don't know if you noticed that the S is parens. What's up? It feels like, I don't know, hours since I spoke to you. What's up? It feels like, I don't know, hours.
Hang on, I gotta mute something here. Yeah, it has been
hours.
I would say merely hours.
Merely. Oh, it's gonna be wambulance o'clock over here. I might have to put my earphones on, but so you and I, well, I mean, I'm sure you've
you mostly.
What?
You mostly.
You mostly what? Talk?
You said, well, you and I said you mostly.
Okay. Well, I at the behest of you, kidding, sort of. You and I spoke quite a bit about contempt. You did a fine. Actually, let me say hello to a few people. Hi, Shabugs. I know that Andrea's over doing a live, and she hasn't been live forever, so maybe we should just all go over there. Hi, Royal We. Hello. Hello. Hello, everybody. So, I think what we talked about, Michael, was because going through the Holeman deposition, because it's a barn burner. I don't know if you've had a chance to sit with it and digest it's all its glory. I assume
it's pretty indigestible.
Where's my Tums? Oh, damn it. I usually have Tums nearby. That's #old. But so I was saying last night that I was interested in obtaining the deposition from Holeman because I started looking into this whole idea of contemptuous conduct by, the defense attorneys through this leak of photos. And you and I have talked about this quite a bit because I'm a little bit obsessed, maybe OCD, I don't know, about tracking down this timeline. And you made a really good point on the Twitter machine where you're super famous, have so many subscribers, which directly funnel to your Griftopia YouTube channel, and made a really good case about why the release of those photos, even if it wasn't a leak, it didn't amount to a leak because they're public information. And that was something I had never even thought of or knew about. What I want to talk about that a little bit, but then I want to talk about how we think about contempt, how you and I have talked about contempt and what it is in the context of what happened and how weird it is that it happened within the body of a full-blown murder trial. And what, if anything, could come of, let's just say hypothetically, one was to find out that the state had misrepresented something, is there recourse? So that's kind of it. So And I know that you were involved in the contempt filing. So where do you want to start?
Yeah, a day,
A day that will live
a
in
day I
infamy?
may regret. A day I may regret for a
Now,
long time to come.
why is that?
Well, because so before the contempt stuff, my only real involvement
Mm-hmm.
was ironically enough, the murder sheet got in touch with me and they wanted me to come on and talk about the second original action,
Okay.
which I did.
Yes.
And it was a pretty great discussion. Now it was really interesting to see what the people had to say in their Facebook page before I was blocked. But it was a pretty good discussion. I mean, we went through sort of the four possible outcomes, right? I mean, the lawyers, nothing changes. The lawyers.
But wait a minute. So let's put this in the timeline of events, though. This is after the supposed leak of photos, but before McClelland filed his information for contempt.
Right. So the Supreme Court puts the lawyers back on pretty much right away, but it issues. So I think they issued an order pretty immediately, and then about a month later, after the argument, they issued an opinion. And I think it's right after the opinion issued that McClelland filed the contempt information. Basically invited to by the Indiana Supreme Court opinion by Justice Moulter.
How so? How so?
Well, Moulter's opinion, to be imprecise, because I'd have to go read it again. It's been a while, but my recollection is that the opinion was basically, yeah, maybe you could do this, but you didn't do it in the right way, so let's have at it again.
I see.
So
Nick just takes. Go ahead.
No. Instead of saying, it was almost like it was a little bit like Gall's not finding them in contempt, the lawyers in contempt in the end, where she also took a completely gratuitous swipe at them, saying, they were negligent and grossly negligent, blah, 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 but didn't find them in contempt. It was, Moulter didn't have to say, the Supreme Court opinion didn't have to say, well, you just didn't do it in the right way.
Right. Yeah. Well, I mean, it's like Nick getting all of his information from judges through winks, nods, whether it's emails or rulings from the Supreme Court level.
But yeah, well, of course, way back when, before it got to the Supreme Court, and actually before the lawyers were removed, I think there was an email exchange, or maybe it was in a hearing. There's a transcript of where Nick said something about, thinking that the lawyer should be disqualified in view of this leak, and I think Gall said something like, "I'm inclined to
believe." Yeah. So is there, okay. All right.
So what I did, I think, so what I did and this is really a result of you repeatedly telling me, look at paragraph 12, dude, about the contempt information. Look at paragraph 12.
Yeah.
And look, the thing I filed on the contempt thing was almost entirely procedural.
Mm-hmm.
And that's kind of, and right, I did the chronic thing in the motion to correct error. That's entirely, I mean, there are facts involved, but it's a procedural issue.
Mm-hmm.
And, you know, I'm kind of the procedural guy, and so once I looked at paragraph 12, then at your insistence, well, no, and I mean that in a good way. I mean, you realized something, you know, well before I did. So if you look at paragraph 12, it takes uses up 11 rhetorical paragraphs before McClelland does, before he sets out what the leak was. And he says very specifically that the leak were all pictures from the Franks memo, exhibits from the Franks memo. When we're talking about Frank's memo, folks, we need to be clear. The motion for a Franks hearing was publicly filed. The exhibit list for the memorandum in support of that motion, the exhibit list, was publicly filed. For a very brief time, and
I just
somebody
pulled
was
that up.
somebody,
I'm just putting this up
somebody,
because I want to make sure we go through this and show people. So yeah, here's a list of exhibits for the Franks, and this is all available on All Eyes.
and for a very short time, long enough for somebody really quick on the clicker to get it, the Franks memo itself was on the public docket. But it disappeared, and there were never any of the exhibits on the public docket. And you know, I did about, I think it was a third. People have criticized me, some of them mercilessly, about, oh, you know, what kind of lawyer does 30-piece Twitter threads about things like this? But I did I think it was a 30-piece Twitter thread about why legally, under the access to court records rules, ACR rules, the stuff, those pictures were public documents at the time. On October 4th, they were leaked. I mean, at the time, so we know that those pictures start showing up all over the internet. Various people, I mean, I think it was much earlier, but the allegation in the contempt information is that, I think he just says early October, but we know from various documents that it was the night of October 4th into the morning of October 5th, sometime in there. These pictures, at least some of them, start showing up on the internet, and people start losing their lunch over it. And you have to realize that the Franks memo, now when I say the Franks memo, it's the memorandum in support, it's not the motion. So the Franks memo was filed along with the motion on the 18th, and the exhibits were taken to Gall and to McClelland.
Right.
And that's actually what's causing the appellate lawyers now. The appellate jockeys are having the problem because those things never showed up anywhere. And we really don't know what was delivered. I mean, we have a list, but, you know, do you even know if the list is, you know, do you know what's in the exhibit list was actually delivered to Gall? Who knows? Or to McClelland. I mean, look, people make clerical mistakes all the time.
Yeah.
Apparently people over-record days and days and weeks of video recorded interviews all the time.
Happens all the time. Happens all the time. Yeah.
But in any case, so the Twitter thread was really about how, even though these things did not show up on the docket, the exhibits, right? So we have McClelland saying all of these pictures that were leaked came from the Franks memo exhibit. All of them. That's what he says in paragraph 12. This is a contempt information. Prosecutors are stuck with the allegations they make in a charging information. This is equivalent to a charging information. You're saying, you know, you violated the protective order by leaking this stuff. and you're stuck with the stuff. I mean, you can't accuse somebody of stealing a bicycle and then say, oh, by the way, now that we're at trial, you actually stole this person's lawnmower instead.
Right.
You just don't get to do that.
So I want to just clarify here. So what we're talking about, and I agree that McClelland buried in this, what I have up on the screen right now is the information for contempt. And it is really until he wastes all sorts of space and all sorts of time padding this one paragraph that purports to relate to the Frank's motion as being the nexus, if you will, of all of these photos. And this is filed, for everybody who doesn't know, very late January 2024. So again, so to just sort of place this in time, you know, and I'm starting to look at it sort of retrospectively from Holeman's deposition, which was batshit crazy, where he admits, well, we'll get to that, but he basically admits, yeah, I've seen a lot of this stuff, I've seen it, whatever. But from August 10th to the October 4th date, there's a lot of stuff going on in between there in legal filings, etc. But then it's after October that everybody's, you know, ripping their shirts off and running through the street screaming over this quote unquote leak of crime scene photos. And then they get kicked off, get put back on. Then Nick goes basically straight out and files this information for contempt. And what you're saying, Michael, is that this motion for contempt is basically like, well, this is maybe not a great analog, but sort of a charging document. So you're like you said with your lawnmower versus bicycle analogy, you know, you can't change it. You have to live within what you've presented in your document to the court. Yes? Hello?
Yeah, I lost you there for a second. So what? The lawnmower versus the auto. What were you saying?
Just bringing everybody up to date that basically McClelland is held to. This is basically a charging document. By if you want to think of it in that way, it's your analogy is to a criminal, but this is a prosecutor's information, which is sort of the same thing. You have to hew to the allegations in this document, which is the Frank's memo.
Yeah, and I'm looking at the docket of the second original action. The Supreme Court. So the lawyers were put back on the 18th of by order, were put back on the 18th. The opinion of the Supreme Court in the second original action didn't come down until the 8th of February. So in fact, McClelland filed his contempt information before the opinion came down.
Huh. Okay. All right. So he had an original thought. Okay, go on.
So anyway, I was looking at so, you know, the point I was making on Twitter was that, you know, to file something confidentially under the rules, and, you know, I can go into the details of it, but it's really the too long don't read version is, under the rules, unless you do certain things, the presumption is that things are public records. And nobody did any of the things there are two things you have to do. One, you have to file a notice on the docket that you're filing confidential stuff. And the second thing you have to do is attach ACR forms, I think it's ACR form 9, to anything you're filing confidentially, identifying the rule under which this is being filed confidentially. Now, there is a provision, so it's really not discretionary. You can there is a way you can try and make a case to the judge that these things should be filed confidentially, but it's particularly interesting that ACR Rule 5, I think it's B11, says that the pictures of live people showing private parts are confidential, but by implication, the pictures of dead people showing private parts are not to be confidentially filed. And just none of this stuff was done filed confidentially. And if none of this stuff was done, all of this stuff was public record, and letting it out was no big deal. This was all in the public domain. And I want to, even if under on some bizarre theory, and we can get to it when we get to the exhibit list, the Frank's exhibit list, you think that in fact they were filed confidentially, but the Frank's exhibits, right? No reasonable person looking at the docket would think that was so.
Because there was no accompanying ACR Form 9.
Well, we don't really know whether they look. I just know that Andy Baldwin did not file an ACR Form 9 with those exhibits. I mean, I would be shocked. We don't know, because those are to be filed with the documents when you're filing them confidentially, so the judge can look at them and say, yeah, okay, they're confidential. But what wasn't filed publicly was the notice that anything was being filed confidentially. So anybody looking at that would automatically think, oh, there's no notice. They didn't do what was necessary to file something confidentially, so they're not confidential, and I'm free to do with them what I want. So I'm saying even if the defense themselves, right, not these internet people, I think the defense themselves, the defense lawyers themselves, if they wanted to, could have released them, all of them.
Okay, so my question is immediately then, where does the protective order come in to force? Is that not?
Well, so the protective order doesn't say anything, but look, stuff that's protected under the protective order doesn't say, look, there are provisions in the ACR rules, and I think it's in 5A, unlike 5B, which I was talking about a minute before, about, pictures of private parts of live people.
Right.
In 5A, there are provisions when an entire case is confidential. But there is nothing in the protective order that says if you use discovery in a filing, you shall file it confidentially. Look, it's a public record. I mean, and the court's protective order can't override the ACR rule. I mean, it just can't. If you want to seal the case, seal the case. You want to say, you can try to. I mean, but they didn't do that. So the protective order has nothing to do with filing stuff confidentially. It has to do with sharing things with people, and it
I see.
Nothing,
okay.
It has nothing to do with exhibits and what are like your motion's a public document. I mean, the whole point of this, I'm not a huge fan of everybody's talking, transparency. Well, the ACR rules are all about presumed transparency. And, basically ACR Rule 4 says, unless something's made confidential by ACR Rule 5, it's a public record. The public has access to it.
Okay. So what Nick is doing here is just, even if all that was, even if it were, so let's just say that all the photos, just Andy Baldwin flew over Indianapolis and just dumped out buckets of these, like leaflets during WW2 and never mind. But you know what I mean? He could have done all of that. Well, but he would have been sharing it. I'm trying to think of the argument.
No, but sharing it once they were filed as
Mhm,
part of the Franks memo as exhibits,
mhm.
what he's sharing is not the discovery, he's sharing the exhibits.
Got it. Okay. So that's when it moves from okay. I got it. I think I get what you're so he could dump them out of an airplane.
I think so.
Okay. So
So
basic
that's the legal that's the legal argument.
right.
But there's a
So,
factual argument too.
well, and before we move on from the legal argument, that this should have just been well, and you filed your motion to dismiss, where uh, once, twice, three times old as dirt, I think made it into your filing, which was really beautiful introduction to the Ausbrookian School of Legal Studies. But Gull should have just looked at this and said, nah. I
Yeah,
mean,
she absolutely should have dismissed the thing. You filed it in the wrong place, Bob. I can't do this. You want to do this, file it separately. And frankly, after she denied that, not my decision, but boy, I would have been going back to the Supreme Court a third time.
mm-hmm.
And by the way, I mean, and I've said this multiple times before, Dave Hennessy at the contempt hearing on March 18th, 2024, put in state court administration's bench card.
Oh yeah.
So they have these little cards that tell state court judges how to do things, right?
Mm-hmm.
And I mean, it's kind of their administrative help. I mean, like all judges don't know all things, and I mean they're humans, and who knows? Maybe they never dealt with contempt. My motion to dismiss said nothing. It had some law that was almost older than dirt on it, but fundamentally it said nothing different from what state court administration's own bench card said.
Right. So I've pulled that up. Yeah. Yeah, and I think that everybody should read this though, because of the older than dirt arguments. Let me see.
I didn't really mean that as snark. I mean, this
No,
is
no, no,
literally
no.
true. I mean, this stuff is not subject to debate.
Right.
I mean, there was only one case. There was only one case in which I could find a criminal contempt case happened inside another criminal case, and that's where the defendant was the one who was being held in contempt. And
The defendant themselves.
The defendant. So yeah, so it was the equivalent would have been if Richard Allen had been found in criminal contempt.
Got it.
And by the way, I looked fairly closely at the docket of that. Nobody made the objection to the defendant being subjected to indirect criminal contempt proceedings inside his own criminal contempt case. I think it was he, violated some sort of protective order of the court, and so it's indirect contempt because the violation happened outside the presence of the court. So, but you just, you don't file a indirect criminal contempt inside another case. You just don't do it.
Well, and I think that this moves us into sort of the factual, to me anyway, because you just don't do it. What you're saying is sort of the pattern and practice of Nick McClelland and the state of Indiana in this case is that nay, we do whatever it is, and we do actually get away with it. And everything, and I've said this before and I'll say it again, everything that the state did or has done is a tell. And everything that, it's like, what do you say? Just keep talking? You want these people to just keep on talking from the state. I mean, the more information that comes out, the more we realize they're giving the game away. So when Nick, hauled off and did this information, which is just procedurally ridiculous, but also I am convinced factually baseless. And it's just another way of trying to I keep saying, I can't remember, pervert the course of justice. What is it? Obstruction.
That's,
Yeah, obstruction.
yes.
So
Yeah. You've
So-
been studying too much British law.
I know. But that's sort of what it starts to smell like, is state interference with counsel. I don't know. But let's talk about the factual stuff now that
Absolutely. So, and here's the, and by the way, although it wasn't, well, we'll get to this in due course, but remind me, there's another argument other than Frank's memo made these exhibits public records. There's an argument that I haven't made yet publicly, that once anything that was attached to Holeman's deposition as an exhibit, the depositions are not discovery covered by the protective order.
Oh.
They're not discovery from the state. And I would say that any exhibit attached to the deposition is no longer discovery. It is now an exhibit to the deposition. So if any of the pictures, I'm jumping ahead a little bit, and we'll do this in, I think, a more methodical way, but just stick a pin in this, that any of the pictures that were attached as exhibits to Holeman's August 2023 deposition, that were also pictures attached to the Frank's memo as exhibits, were already no longer covered by the protective order once they were attached to Holeman's deposition.
I like that argument as well. And that's another procedural thing. So that's two items, right? Because and I just pulled up the exhibit list from Holeman's bizarre deposition on the 10th. And so I am going to put a pin in that, because I think that what I struggle with, well, I don't struggle with it. What I think that people, I hope, start to realize is that there is absolutely there was no grounds for bringing a case of contempt. That my belief is that after reading this August 10th deposition, it became really clear. It's like I said in my little TLDR, it's like they knew they were fucked. It's kind of the sense I got from Holeman. But after reading that, seeing all of the sort of like when Baldwin and Rozzi are introducing the list, and we have the defendant's exhibit A is Abby's photo, the photo with the asterisk, side by sides, tree markings, stick photos. They include a supplemental report, the if a tree photo. Okay. A side-by-side and an ISP report. So in there we have, what is that? What did we figure out? 6 photos? Wait, 1, 2, 3, 4, 5, 6, 7 photos. They're alleging, or that were entered into Holman's as exhibits into his deposition. And you know, uh, uh, the reason I think that this is really critical that people understand is that while in the information for contempt that we just went through about item number 12, um, the allegation was that it was from the Franks exhibit, because that was a big thing. The state had to show, we're desperate to show that all of this, all of these gory crime scene photos, and we'll put a pin in that, had to, not may have, but had to have come from the defense definitively. And while Nick put that in this information for contempt, what they relied upon in the contempt hearing is, in fact, Holman's deposition and his claim that that's how he knew from Kevin Greenlee, a lawyer who was part of the, still had a filing on file, and Anya Kane, that the way that he knew was because he had never seen those photos before until that deposition. So he instinctively knew, as the investigative juggernaut that he is, from that phone call, that by gum, he knew exactly where they came from. And that's the argument that they tried to put, or that they did put forth in a court of law. And I think that they can be proved to be liars, lying liars who lie. And I'm not sure what the legal term is, but lying liars who lie. So I don't know if I don't even know how to begin talking about that part of it, because
So I think you're starting at an earlier point even than I start. And what you're starting at is the place where Holman in the deposition is shown some pictures and he says, yeah, I've seen those.
Well, I'm starting I'm actually starting at the exhibit page, which I have pulled up, but I sort of jumped ahead a little bit and said, yeah, I saw these and those. But what I'm saying is, when at the contempt hearing, when they had the hearing and Holman was on the stand, he said that he knew, not from the Franks memo, that those photos had to come from the defense, but that he knew from his deposition that it had to come from the defense.
Right. And what I'm saying is that because of the place, and you know the deposition a whole lot better than I do, but isn't there a place where he's shown pictures and he says, yeah, I've seen those before? And
Yes.
so he's lying. So if that's true, then he's lying at the deposition when he's lying in the contempt hearing when he says, yeah, I saw those I saw those at the deposition. I don't know that he says he saw it for the first time, so maybe he's not lying. But the inference that McClelland's trying to get court to make is that Holman had never seen these things before. He saw them at the deposition. Obviously, if he'd seen them before, then he saw them someplace else before, not from the defense. And so those pictures could have come from someplace else.
Mm-hmm.
But well, I want to go to the, so I want to go to the other source, and that is that in the normal course of the deposition, the deposition's done, the exhibits are attached, given to the court reporter. And then normally the parties, that would mean Brad and Andy and McClelland, would get copies of the deposition, and Holeman would probably get a copy of the deposition. And I can't prove that he did, but Holeman would get a copy of the deposition with the pictures. And so McClelland had the exhibits from the deposition for sure.
Yes.
And I think we've actually got a date for that.
Yes, on August 18th. On August 18th, he received. So the deposition was done on August 10th. It was completed and, by the reporter and sent to McClelland on August 18th, and with exhibits. And I know that for a fact.
Right. And we're trying to find, and it's worth finding out whether Holeman got a copy too. We can figure that one out. But all I'm saying is that this whole case, that these pictures, to the extent that the pictures in the Franks memo were the same pictures, and Jerry Holeman says that they are, some of them anyway. And right, he's yeah, I saw these pictures at my deposition. So some of the pictures presented as contempt, the leak was contemptuous. We know multiple people had access to them and could have released them.
Oh heavens, yes.
And we have to go back to everybody's going to say, well, what about Westerman's affidavit? I mean, he took pictures of pictures and the thing. Yeah, but we don't know what picture they had. If they wanted to make a different case, they had to put Westerman on the stand to say, yeah, that's a picture I took and I sent it to X and X sent it to Y and Y put it on the internet, whatever. But Westerman only says, I took pictures. He doesn't say what pictures he took.
Right.
And frankly, it would be a remarkable coincidence if the pictures he took just happened to coincide with the pictures in the Franks memo.
Well, and so here, let me just say this. I'll say this about the Westerman thing. I don't even need Westerman at this point to where I'm going. And I don't think that it's even the fact that was even entered. I know obviously, that was supposed to show something. It didn't. It failed. It failed to show anything that was germane to the hearing. But I would just say, because so I'll say this about Holeman. I'm gonna have to remember where this is, whether it's in I think it's in the contempt transcripts, where he says he admits to knowing that, or he admits to having at least seen his deposition and not signed it because there were, quote, so many mistakes in it. Now,
Yeah.
but I'm assuming you don't get a copy of your, it's not like, here you go, your deposition's done, take a copy of your depo with you. I assume that it would have to be something that comes after the fact. Right?
Yeah. I mean, yeah, because the court, the person who was acting as a court reporter had to type it up. So
Right.
yeah,
So
I mean, he would have got, he probably gotten, he either got it directly from the court reporter to sign, or he got a copy from McClelland.
yes. So I guess my point is that, while we know that Nick McClelland got a copy, we also know just through his testimony, it's sort of leakage, seepage from Jerry, which is gross. Sorry, that was so gross. That he said on the stand that he refused to sign his depo. So so we know that they had it. The idea that somehow it evaporated into thin air, never to be seen again. After that, after he walked out of that door and accosted poor Officer Murphy, it's just, nonsense. So I just wanted to, but I wanted to say that because you did say we don't know if Holman had it, but I'm going to spitball and say he sort of told us he did. But regardless, we know McClelland had it, and therefore that is the state, right?
Yeah, and the whole idea, because they didn't tie Westerman, so they put Westerman's affidavit in, but he only said he took pictures.
Mhm.
Because they didn't have Westerman to say what pictures he took, they didn't, and they had nothing to tie Westerman to the pictures in the Franks memo, which were the allegedly leaked pictures. And so they had to make a case by inference, circumstantial evidence, that these pictures that were leaked onto the internet by various people had to have come from the defense, because only the defense had these pictures. And that's just not true.
Right. I mean, just even on its face.
McClelland had the Franks memo. Gulls Chambers had the Franks memo. Multiple people had multiple people had, and don't forget that this Gary Baudet character in California was saying he had a source inside the court.
Hot crap, he sure did.
Well, I don't know whether he did or not, and it's hearsay.
I know, but no, that's what I'm saying. He made that statement. He made the statement,
and Hennessy wanted to get him. It would have taken time because he was out of state. Gull would not continue the hearing. I mean, that's the other thing. I mean, you've got a trial scheduled for May, and Hennessy quite reasonably said, can we please put off this contempt BS until after the trial? I mean, this really doesn't affect anything. Oh no, we have to do it now because what? The sanction, the contempt sanction, is going to be what if she finds contempt? Remove them again.
Right. Well, and so I mean that raises all sorts of other issues when talking about the specter of state interference with counsel. I mean, I think to your, and you will say this rightfully, that was sort of that Rubicon was crossed when she told him to stop working on the case. But this would just be, to me, if proved that McClelland and Holeman truly misrepresented to the court what was going on in order to try to derail again a double homicide trial, it seems to me that could create legal issues for both of them individually, but the state. Is that possible?
Yeah, I think so. I mean, I think there's a state interference with counsel. I mean, yeah, if you can prove this was cooked up and they were lying, and we've got some pretty good proof. Not in admissible form yet, but I think it could be gotten in admissible form. McClelland says that he learned in early October about the leak, and actually from I have the contempt file report that Holeman did. This is all showing up at 8:00 in the morning or before on the 4th of October, and we've got pretty good evidence that McClelland was already had his hair on fire about pictures running around the internet on the 30th of September or earlier.
That's a grease fire.
You said it, not me.
You're the one that gave it to me, so it's a grease fire. But yes.
Well, don't put water on it. No. No, but my point is, I mean, but if he did know about it on the 30th, then he was the contempt information was signed under penalty for perjury. So he lied to the court in the contempt information.
I mean, it's my opinion he did anyway, but that's based on, what we know about the investigation, the quote unquote investigation, that shows some very, very tenuous, difficult to believe, series of events, and even cannot even seem to get its own story straight. Some of the investigative assertions that Holman put forward about how he realized it was, it's telling. Well, I don't know what I can and can't say, but it.
So what you can say is let's even move forward to the state's own case in the contempt hearing about the actual evidence. And
Right.
we know from, and I really don't know why there weren't objections all over the place. We know that one of the pictures was, at least one of the pictures was a nude of a girl. I don't think we know which girl from the testimony, but Holman says two things about that picture. He said, yeah, that came from the defense because we use rectangles to redact pictures and they use ovals. And then he says, and we haven't seen it, this picture has an oval and a rectangle. I don't know why, even if the defense did use ovals, which I doubt.
I don't think that's right, Michael. Hang on. I think he said rectangles. Hang on.
No, he said the law enforcement uses rectangles, the defense uses ovals.
No, I know, but when he was sitting in the dock,
Yeah,
didn't
he says
he?
this one has both.
Oh, he did?
Oh, I'm almost certain.
Well, then how can he make a claim that the state wasn't involved?
It just doesn't. Nobody's. Look, go find it. Tell me I'm wrong, but I swear that's
Okay.
what it says, and nobody's raising a stink. Let me put it differently. Let's say he doesn't say that, right?
Right.
I'm here to tell you, I have confirmation that that picture had a rectangle and an oval on it, and
Yes.
obviously the defense had to have seen it, and I don't know what people were thinking.
But
I mean, I don't know what McClelland was thinking.
here's what I hear. Well, and so I think that we need to make that. So we need to make that clear, though, for people, is that we don't know what's, and that's an exhibit 5. Let me see if I can pull up the exhibit 5 was the thing from the contempt hearing that we've not been able to obtain, but we've been able to verify that there is this redaction on it. But we also know that there is no, that neither the state nor the defense had any reason ever to utilize any redactions, because it was a criminal trial, and that is just not something that would be presented as an exhibit, no matter whether it was in a deposition or not. And so we know that whatever they entered into evidence certainly didn't come from the defense. I mean, can we make that presumption?
I'm not willing to say that. I'm willing to say this, and that is, and I swear he says
Maybe he
that
does. Let me check.
that picture. I swear he says that picture has both. And once
Okay.
he says that, I don't know why. Look, if the defense wasn't using redactions, why aren't they? Why aren't Rozzi and Andy Baldwin? I guess it's Rozzi. I've been told by people who should know. Why aren't
Mhm.
Rozzi and Baldwin screaming in Dave Hennessy's ear? Put us on the stand. We don't use redactions.
So this introduces, I'm trying to find it right now, but I do think a possibility, and I'm with you. I mean, I would have been tearing my hair out if it were me and they sat there and said all those things. But uh Rosie did say at one point, I've never seen that before.
Yeah, but yeah, and that's fine. I mean, there's a ton of stuff, and
No,
look,
but
I don't know. I don't know why Rozzi was there anyway.
right. Hmm. Hmm.
I mean,
Um,
I mean, that's just, geez. I mean,
okay, let me
what
find,
did
I
he
think,
do exactly?
yeah, right. Um, Let me see if I can pull this up and we can find out together. Um, okay, so this is the direct examination of the Jer Bear Holman. Um,
Yeah, just hunt for oval,
I'm
or
doing
maybe he
import.
says rectangle. I know talks about rectangle, so hunt for rectangle.
Yeah, so here it says so the question is, I don't want to go into detail, but what are those photos of? Answer, some of them were crime scene that again, I knew had to come from the defense attorney because one of them was of Liberty and her private parts were blacked out and they use a circle. And in all the ones that we ever use for any type of reason, we use rectangles.
Yeah, search for rectangle again because I swear he says they have both.
Okay, please
The
stand
the,
by
the
1
picture
moment.
he's looking.
Rectangle. Uh, some of the crime scenes are new defense attorney. So we use rectangles. Like I said earlier. Um, so question, okay, and again, the one specifically of the crime scene depicting Liberty, was that something that law enforcement created? Answer, no. Question, and how did you know that? Answer, like I said earlier, we use rectangles to block out the private parts, and that one had a rectangle. Okay, you're absolutely correct. A rectangle and a circle. So I knew it couldn't be produced by us.
I mean,
Yeah, you're right. No, you're right.
Lordy, I mean, and why isn't there an objection on relevance grounds?
Right. All of it. Ba, ba, ba.
I mean,
So
their
in
own damn evidence. I mean, his testimony is that from their own damn evidence. It didn't. I don't know where it came from, right?
right. I mean, because he's saying, in essence, I know that it didn't come from us because we use rectangles, but this one has a rectangle and a circle. I mean, I would stand up and say, move for immediate dismissal based on what? Because isn't he saying, in essence, that it has one from each of us?
Yeah.
What? Let alone the fact that there weren't, let alone the fact that there weren't redactions on what was filed into evidence for the Frank's motion or for Holman's deposition. So setting all of that aside,
Well, we don't know that officially.
so do you think, and this is a serious question, do you think that a lawyer would enter into, say the Franks, that they would enter redacted photos into that for the court record?
Look, with a
I
protective
don't
order,
know.
would a lawyer imagine a circumstance where you might? Uh, but um, no. And by the way,
You're starting to break
I've
up,
seen
Michael.
public records of a guy, who had his. So I've seen pictures, pictures in a record. They're public records of a guy whose, head was split by an axe.
Yeah.
It wasn't redacted. Um, it doesn't. No, I mean, in the normal course of things, no, you wouldn't. But I mean, the phrase book, the Rick Nation phrase book, this is not normal. Anything's
Right.
possible.
Right. That's the Holeman. Stranger things have happened. I mean,
but it's interesting. I mean, that's the other thing. If the defense did not use redactions at all, then Holeman is out and out lying that they did.
I know. And I'm saying that I believe that to be true for a couple of different reasons that are known unto me and probably you ultimately, but may become, and that's why I believe that this is an out and out lie. I just do. And I think that, and people can point to, well, why didn't they say anything? Well, I think that we can all complain about whatever happened with the defense, but I do think that there is something to the fact that Rosie was probably sitting there thinking, why am I even here? And Baldwin was probably, 2 degrees from curling up in a ball. So that doesn't, but my point, I guess the thing is that again, my goal here is to put the burden back where it should be. And we can be critical of the defense and what they did or did not do. But at that moment, what may be true and what may prove to be true is not only that Holeman lied, but that possibly Nick McClelland induced him to lie.
Well, it's almost right. It's kind of a criminal case. It's criminal contempt.
Mm-hmm.
And what did he do? He put on that he knew was false.
Mm-hmm.
It's almost it's a Napoli gossip thing.
Yep. Yeah. And Napoli gossip, just so people know, which is one of my faves. Go ahead.
Oh, I thought you were going to do it.
Nope.
Prosecutors can't knowingly put on false evidence, and that there are two aspects of that. They can't put it on if they know what the testimony is going to be and that it's false. They just can't do it. But if a witness testifies and the prosecution knows that evidence is false, they have a duty to correct it.
Okay. And that is referring to the Napoli gossip is referring to a Supreme Court case from Oklahoma, as it happens. It's called glossip, but it was basically a reaffirmation of the findings of what you just explained in a previous case called Napu or Napuli. And so that was in the motion to correct errors as well, for other reasons. So I guess, so if we look at just this one thing, if we look at it through the lens of Exhibit 5, which is they're alleging are the photos that truly only the defense could have had, I think that any sentient being who has been in that universe had to know that just could not have been true. Number one. Number two, that the information that was filed, why at the contempt hearing did all of this other information get to be introduced as if gospel from Jerry saying, I saw this at the deposition. And so I guess I'm so they can just introduce whatever they want.
What do you mean they can do whatever they want?
If they have to stick to the argument that they made in their information for contempt, which is from the Franks memo, and Jerry is up there saying he started this investigation because of the knowing that the came from the defense, because as he's testifying to at the contempt hearing, because he had seen them in his deposition. I'm not sure how on that on its face, is that not, I mean, it's just, that has nothing to
It's
do with the
bonkers.
Franks
The whole
memo.
thing. No, it isn't. I mean, this. There was never a contempt case to be made, at least not on any pictures that came out of the Franks memo and or Holman's deposition. Period. The end. If they wanted to get, the only way they were going to make a case at all would be to get Westerman in to say, yeah, these are the pictures I took.
Mhm. And they didn't do that.
Well, and I'm saying I don't think right, and that's the factual case, and that's the only factual case they had, but they didn't ever have a legal case because these things were public records, either because they weren't. I mean, they were no longer subject to the gag order, the protective order, either because they were exhibits attached to Holman's deposition, or because, and more certainly, they were exhibits attached to the Franks motion, and they had not been made confidential.
So in the arc of this whole narrative here, and because I do think that, I mean, I believe that they straight misrepresented and lied. I think that Nick McClelland, based on the evidence, based on what I've seen and what I've read and people I've talked to behind the scenes and documentation I've seen, is that McClelland just straight lied to the court in that filing in January of 2024. In addition, I do believe that their entire quote unquote investigation was predicated on a known falsehood. I really truly do, with a, and I think that that can be borne out through the state's own testimony over and testimony and pleadings through depositions and filings. I do think that that can be shown, in addition to the existence of photos actually being out there. I do not think that there was a good faith. There was good faith in any of this. And so if it gets to the point of, say, filing an information of contempt against, let's hypothetical this, filing an information for contempt against Nick McClelland and or Jerry Holman in this instance, what is that? First of all, is that possible? How could it happen? And if it is proved, if it is borne out to be true, would that then would that parlay itself into an argument for state interference of counsel? And is it something people should think about?
Yeah, I mean, I think it could be state interference with counsel in a post-conviction case. It could be if if Rick gets a retrial. Nick may be getting his first trial. We can go into that in a minute.
Yes, please.
But if Rick gets a retrial, it could be grounds to disqualify McClelland, maybe. I mean, look, it's lawyering. There are arguments maybe to be made on both sides. But yeah, certainly a possible state interference with counsel. Nick McClelland represents the state. Normally when there's an Indiana case, and I think it's wrong, that says state interference of counsel has to come from an order of the court. Well, I think that when Gull ordered the lawyers, albeit in an email, to stop working on the case, I think that qualifies. And I think that case is wrong, that it has to come from an order of the court. But I think that if it's demonstrable that Nick was knowingly putting on false evidence in a sort of quasi-criminal case against the defense lawyers, and that actually he committed perjury in the contempt information. Again, all subject to proof. I mean, and I think we've developed a good bit of it. I'm not saying it's all conclusive now, but I think there's a good. I think there's a good case to be made for indirect contempt by Holeman and McClelland.
So tell me what that would look like, though, because I do have a question about immunity and prosecutors and law enforcement.
Well, so prosecutorial immunity is about civil stuff to start with, but the way contempt works, the statute's pretty interesting. People who can file a contempt information by statute are A, court officer, or B, any responsible person.
Okay.
So when Nick files the contempt information against Brad and Andy, he's not filing it as a prosecutor. Normally, you'd file it, somebody files it, maybe even the prosecutor files it, but it gets referred probably to a special prosecutor. It's not that Nick is not filing it qua prosecutor. He's filing it wearing a completely different hat, court officer or responsible person. I think he even mentions it in the contempt information.
Okay.
So he's not. So yeah, he's the prosecutor at the criminal contempt trial, but he's not the prosecutor when he's filing the information.
Got it. So that does make sense. That makes sense.
And the other thing is, prosecutorial immunity is not going to protect a prosecutor for contempt of court for lying to the court. I mean, you can get him for direct, right? He starts swearing at the judge, He starts saying to Gull all the things we think about her, and she holds him in direct criminal contempt. But his status as the prosecutor isn't going to protect him from that.
Yeah.
So it's not. Yeah, I mean, we can argue about whether if you brought a civil case against him for malicious prosecution.
Ooh, I'm writing that down.
We can argue about whether he'd have prosecutorial immunity for that. Of course, we've already got Mr. Luttrell up in the Seventh Circuit arguing he should have had prosecutorial immunity for the horrible things he was involved in with Mr. Economan, Dr. Economan. It seems to be a specialty of these people.
But
no,
okay, so
I don't say that lightly. Look, we have a process. I don't agree with the decisions, some of the decisions the prosecutor down here makes, but I think the stuff is done in good faith. People's judgment. There is nothing in this whole contempt thing that looks like it has anything to do with good faith.
Right. Yes. And so, so going back to, so you explained that about McClelland and how he's not shielded from, lying to the court. What about Holeman when he's on the stand? I mean, I know that I don't know to what degree immunity for cops really extends. They can't just give false testimony, right?
No, they can't. And there's a really nice Indiana case. It's not exactly analogous, but it's close enough. Where the Supreme Court said, yeah, you can hold somebody in indirect contempt for lying about who took some pictures.
Okay.
Um, and so, I mean, that's kind of what they're, what was I going to say? I think what I was going to say was, I think is, I mean, right? They're lying about where these pictures necessarily came from because they know they tried to put on this case by lying to prove that they necessarily came from the defense when they know full well they did not necessarily come from the defense. And in fact, we know, given on Holeman's own testimony about the redactions, the circle and the rectangle, on his own testimony, this picture did not come from the defense.
Yeah. Yeah. And so, and again, you know,
And by the way, I also know that in Exhibit 5, that picture is the only nude.
Mm-hmm. Mm-hmm. Yes. Yeah. I mean, you know, yeah. Mm-hmm. And
you know, we've probably been over this before, but let's just go back to January and February of 2023, when everybody's favorite people pretending to be lawyers, Brett and Alice.
Oh God.
They've gotten pictures. I think they say they've actually gotten pictures, but anyway, that there are pictures out there, and they've gotten in touch with the Delphi Police Department. I think they say Delphi Law Enforcement. And then in February, Doug Carter says there are pictures out there, and it is in fact, I believe, if you look at the timing of it in 2023, I believe it was shortly after Carter's revelation that the protective order went in, that McClelland asked for the protective order.
Oh yeah. Yeah. That's right. But yeah, so that is true. So I mean, we all know that this stuff has been out there, some form, some shape or fashion. Some things have been out there. We do also know that on 2 separate occasions, as you mentioned, Brett and Alice, the upstanding citizens that they are, reported to the Delphi police, and then said that they, you know, followed up with another email, whatever. And then we also know that there is an email out there to Carter about, and I think that's kind of where we're going here, is that hey, there's people out here on the internet offering these things up. And so they were aware of it. 2 different law enforcement entities were aware of it. We see through Holeman's own deposition that Rozzi is being very straightforward about, look, you know, what's happening with the integrity of this? Why are all these things out there? It's almost like they're pushing the state to button up things, is kind of the impression I got, which is weird. And maybe that's where they got the idea, but and you know, again, Holeman is making, and you know, Holeman could have misspoken. I do, whatever he says, but he does say over again, you know, in several instances, yeah, I've seen that before, including, you know, including things from Facebook pages and stuff like that. So I think that you know, in addition to what is within the Exhibit 5 plus comparing it to what is in the deposition exhibits, plus comparing it to what's in the Franks exhibits, is evidence enough. However, I do think is there an element that has to be proved though of sort of intent? I mean, because obviously this, if this is true, if what we're talking about is true, and kind of leaning that way, I mean, it seems that it was very intentional from the way the information was from the time the investigation or the realization by the state that these, that photos were out there, is just whole cloth. And but it was all almost like designed. I don't know what I'm trying to say. Uh, Is there, so I mean, contempt is contempt, but do you have to, is it useful to show like, wow, they really, really meant it? It wasn't just, it was an ongoing, protracted effort over the course of months and investigatory hours.
Are you talking about Brad and Andy, or are you talking about Nick and Jer?
Nick and Jer Bear.
I think you only have to show that they, as you would say, perverted the course of justice, and
Right.
they knowingly did it. I mean, so indirect criminal contempt, one version of it, and it's what Nick charged, was a willful violation of a court order. Now, with any potential contempt information against McClelland or Holeman, you wouldn't be alleging the violation of a court order. What you would do is be alleging knowingly, intentionally undermining the integrity of the court.
Mm-hmm. So what? Okay. So how is that different? The integrity of the court.
Yeah, I mean, there's language. I can't. It doesn't come to mind. There's some of it. Criminal contempt. I mean, if you look at the contempt thingy I filed, there are a whole series of quotes about what criminal contempt is for, and then there are various glosses for it. But under some of them at least, what if in fact Holeman and McClelland lied to the court to put on this whole kabuki theater contempt thing, it fits under one or more of the glosses for that. I don't know whether people know what I mean by glosses.
Yeah, I mean, I think
gloss
so.
is so let's take ineffective assistance of counsel. One version of it is that it undermines confidence in the verdict. Now that's really mushy, right?
Right.
But there's a gloss for that, and that is you only have to show a reasonable probability of a different result, but for whatever mistake the lawyer made. So it's kind of like, if you look at the motion to correct error and the glosset thing, there are slightly different formulations of it. So it's enough to drive you nuts if you're a lawyer. That, oh, there's this one way of putting it. No, there's this other way of putting it. And by the way, it's very interesting when you see quite often so there's an ineffective assistance case, and the court says it doesn't undermine our confidence in the verdict. Okay, that's one gloss. And then when they reverse, they use there's a reasonable probability of a different result. And in the first case, they're avoiding having to confront the idea that there's a reasonable probability of a different result. They're just saying, this is what we think.
Right.
Mhm.
So,
So,
sorry.
whoa, holy crap. Y'all right there?
I always thought of I always thought of the seven dwarfs. I was more likely to be dopey and not sneezy.
But so is it a worthwhile endeavor for somebody to file an information?
I would need more. I mean, I would need to see actual exhibits.
Uh-huh. Let's,
But
so,
you know, if the exhibits if the exhibits, I mean, there's several things I would need, and I don't think I'm going to go into those things and who I
yeah,
need them
no.
from. But
Mhm.
if the things lined up right and are in fact what I think they are, yeah, I you know, I, the contempt information against McClelland and Holeman, I'd file in a minute.
Mhm. And I mean, technically you could. I
Oh,
mean,
absolutely.
actually you could, not
Well,
even technically.
well, I mean, yes, because I may not be a responsible person, but I am an officer.
Correct. No, I think that goes without saying. But you also were, and not that it means you are an officer of the court, but you also did file into the contempt case for the motion to dismiss. So, I mean, you were pretty much, you know, you weren't in the weeds like Hennessy, obviously, or whatever, but you were involved in it tangentially, directly. But so you could, a third, any officer of the court or responsible person. So obviously it needs to come with teeth. But that's, I just think it's interesting as this sort of whole thing grinds forward and the more information that comes out, whether it's depositions or more exhibits or whatever the case may be, as we try to think about the different courses that the appeal can take or whatever. Just thinking about this in the way that it could figure into the interference, you know, a potential state interference counsel. I mean, there's, I'm offended by all of it, but it's at its most offensive. It's because it was filed into, it was within, it was in Mr. Allen's filed under his case number, you know. I don't know. And it seems like all of that is very calculated, just kind of glancing backwards, but I don't know. Oh God, you're muted. Did you die? Are you okay? Oh God. How long do we wait?
I'm here.
Okay. Ooh.
I think so. I think the reason we were on here today about this was because, you know, the light that the deposition throws on all of this, and you know, I think the deposition advances the case substantially that the total contempt thing was BS from the start, especially because if you can line up the picture that Holman says he'd already seen as of the deposition in August, with the picture that was in the Frank's memo exhibit that is also in contempt exhibit 5, I mean, the whole thing was cooked up.
Yeah.
And not only was it cooked up, but there was a little bit of fibbing going on.
Well, yeah, and I mean, I think cooked up is, I think fibbing is inherent in cooking up. Truly, I mean,
Oh, I don't know. I think you can take facts and you can, cook up a case. Look, I could say that the circumstantial I cooked up, that the leak came from somewhere else. Baudette. I mean, I did this on one of Angela Sadlowski's lives way back in, I don't know, March 2024, maybe after the hearing. And I did it for mostly internet stuff and hearsay stuff. I mean, I would say that was kind of cooked up.
Sure.
When I say so they cooked up this case, but they cooked it up out of, faux ingredients.
Yes. It was, yeah, it was all, yeah. So, but yes, so I do think that I wasn't surprised to see Holman admitting he had seen some of this stuff, because how could you not have seen some of this? I mean, anyway. But I do think, to your point, that showing, getting the next, or the logical step would be to find out, even though we know some of the things that are and have been able to confirm what is in Exhibit 5 of the contempt hearing, that still needs to be something that is obtained and compared, like you said, and that is really, I mean, is it stick a fork in it, or no? Is that just heating up the oven?
Oh, well, no. I mean, no. I think we need to do I think we need to do a little grocery shopping to get some real ingredients for our own dish to serve up cold.
Well, I do know of a grocery store. So
Yeah, and I know the same one. I know the same one, and the question is whether what its hours are, and whether it accepts credit cards.
oh my God, let's see how long can we play this out. Well, I mean,
Hey,
I think that I know, and I think that's kind of, that was kind of what I want to talk about. But I do think that people should think about that, that there was this other case, and then as everything starts coming out, I think it's an interesting avenue that needs to be plumbed further. Yes.
Yeah.
Okay.
Yeah.
I mean, I kind of think that's it. Does anybody have questions, comments? I wasn't even looking at the chat, so sorry.
And I think DB was asking about, does this have any consequences for Rick's direct appeal? And directly no.
Right. I mean, a lot of this would be, yeah, if and when there's a retrial, I think you said, and then also, if we need to do a Heimlich maneuver.
Yeah, I was thinking more of the, going with the perverting the course of justice thing, the British thing. I think it's more, I think it's more like the highwayman stand and deliver kind of approach.
Oh, the dandy highwayman. Yep. Sorry, I'm futzing around with my hair. Okay. Well, I mean, I think, does the state ever get consequences for the actions? I mean, who knows, right? hopefully. I don't know. We'll see.
Look, I mean, what has this post-conviction, what has this case confronted? This case has confronted people in positions to do something who don't, for whatever reason. And it's very hard to overcome that.
mhm.
You know, if could be that you know, the grocery store would view it, you know, my going in through the doors as being trespassing, and they're not going to sell me anything.
Yes. But do you have what's your intent though? Yeah. So is the contempt stuff considered part of the four corners? I don't think so. Uh Not for consideration for any sort of appeal purposes. It's just there. Any new, if I understand what you're asking, all eyes, is that any new information that would come out would be part of a the post conviction, and let me think. What else? That's right? So it's in there, but it doesn't really have any relevance to the appeal. So what is, I'm not sure what this is. So I think that's all. My cat's looking at me, so I should probably go and entertain her. Hang on. Let me show. Oh, ho, ho. Oh, yeah. Ha, ha, ha. So it's cat o'clock. There she be. Oop, there's her foot. Where is she? There she is. Okay. Oh, and there she goes. All right. All right. So that's that then. Thanks for doing this with me. I appreciate it. I think
Well,
that
yeah. Yeah, so I'm got my shopping bags ready, and
your little grocery getter.
yeah, we'll get some groceries, and there's actually I gotta go do some clothes shopping first. That's actually there's some fairly urgent apparel I need to purchase.
A wiglet and a cravat.
A wiglet and a cravat. That's it. Yes. No. A blue Carhartt jacket and a hoodie.
Stop it. Oh my God. All right.
Thank you. I appreciate
So-
the opportunity. I hope it's been interesting to somebody other than us.
Well, even if so, you know what I say. I just hate everybody, as you well know.
And
The least. So
okay. Till
all
next
right,
time.
talk to you later. Okay, bye.